What if you pass away without a will? If you pass away without a will, state law fills in the gaps. State law dictates who gets what if you haven't clarified who your heirs and beneficiaries are in a will. State law follows kind of what you would expect people might choose. A surviving spouse is the primary heir, and then children after that. If there is no spouse and no children living, then it goes up to your parents who would receive your estate, and then ultimately your siblings and nieces and nephews until someone is available to receive your estate. But it can be kind of tricky if you have a blended family and either you or your surviving spouse have children from another relationship, because the numbers get kind of tricky and don't just go flat out 100% or in equal shares in the case of a blended family. So even though California law fills in the gaps to make sure that people who are close to you receive your estate, it might be different than what you would want. And it also doesn't clarify who would be in charge of assets left to a minor or an incapacitated beneficiary. So state law is really just following the family tree, but it doesn't really do a whole lot more to make sure that your beneficiaries receive things the way you want, or maybe at specific ages that you might want. So if you die without a will, state law fills in the gaps. But even then, it's really important to make sure that your plan is laid out in writing, so we're not having to rely on state law for you.